And last, but certainly not least, we are super excited to have an industry expert from the field, William Wenzel, who is the owner of Road Legal, who's going to be talking about reports from the bleeding edge, crypto assets, and the law.
Thank you, everyone. My name's Will Wenzel, and thank you for sticking with us till the end here. You'll notice, first of all, I don't have any slides. I don't know how many of you are familiar with lawyers' slides. They're awful. They're all text, and you're ending up reading them. So I'm going to talk about what I do every day. I've been a business and corporate lawyer for about 12 years now. I've been involved in blockchain and cryptocurrency since about 2010. And incorporating into my practice since about 2016. Primarily that looked like telling people about it because most folks didn't know about it. But where we find ourselves right now is very interesting from a legal perspective because, and this title, Reports from the Bleeding Edge, is not as tongue-in-cheek as I'd like it to be. The fact remains that what the presentation could be called from a lawyer's perspective is, and, you know, as a non-traditional lawyer, right, lawyers generally are most comfortable when they know what's going to happen. Been through this a million times. You broke your leg on the property, and there's an insurance policy in place, so let's figure it out, right? That's not my career. And so where I found myself is in cryptocurrency particularly, and crypto assets more broadly, right, we have to do a lot of reasoning by analogy. And so I want to start with a really core concept to take us through this whole thing, which was a bit of a head scratcher for me in law school when the question was proposed, what is the law? And it's not some highfalutin thing. The fact remains that the law is what the courts say it is. Oh, but what about the regulations? And what about these, books full of things? In 17 years of, of doing this thing, right, and in looking at this, like, there's been since that idea was proposed to me, right, there has been no challenge from what I've met that the law is what the courts say it is, which takes us to the situation around crypto assets, right? We have the SEC competing with the CFTC, the Commodities Futures Trading Commission, to figure out who is the authority in charge of the cryptocurrencies and whatever they are. And we have the chair of the SEC, Gary Gensler, saying basically all cryptocurrencies are securities. That's an issue, right? We also have, as of yesterday, $1.7 trillion, just north of that, in crypto assets in the planet today, right? And that's excluding NFTs. I want to give a special thanks to all my prior presenters, by the way, because they did a lot of heavy lifting. I was in the back, and I just wanted to yell out, like, pay attention, there'll be a test at the end, and this is kind of the test, because I don't have slides. So, it's wonderful to have such a great explanation. So I'm going to talk about 3 areas as succinctly as I can in a 20-minute presentation spanning my entire legal career in cryptocurrency, right? And all the uncertainties. We're going to talk about the SEC. Briefly, we're going to talk about DAOs, and we're going to talk about the Uniform Commercial Code, which, despite being eye-glazingly boring for most folks, is incredibly important because we have $1.7 trillion in assets on the planet, and lending against those assets is a key component of any capitalist society. Love it or hate it, we live in one, so we got to deal with it. Having secured lending that is safe and not FTX is really important. So what are we doing about it? But let's start with the elephant in the room. Lately, the SEC says to the world at large, all cryptocurrencies are securities. Now, what does that mean for people who've been doing business in cryptocurrencies for the last, let's say, like 7 or 8 years, right? And now they've carved out Bitcoin, and they might carve out Ethereum too, but that leaves, approximately 7,000 or 8,000 different companies and groups of folks with crypto assets. Right? What happens if you are dealing in an unregistered, unexempted securities? Well, there are sanctions and fees. That's a big deal. The bigger deal, yeah, there's also willful penalties if for criminal activity, you willfully don't register or exempt a security. That's jail time, 5 years per offense, $10,000 per offense. Now, each time you issue one of these coins, that's an offense. Now, willfulness isn't really a big deal here because nobody really knows what they're doing. I mean, I'm practicing this and I'm sitting up here telling you, like, we're feeling around in the dark. I'm fairly comfortable with that, but seriously. The other penalty here is disgorgement, which is a legal way of saying give the money back, which means that anytime you received $1 for a cryptocurrency, now you got to give it back. And that's a problem because we don't necessarily know where those dollars are anymore. Or more likely, you run a business and they're spent, but you have to give it back, which is why Coinbase is in such up in arms about getting dealt this Wells notice that you mentioned, which is essentially a notice from the SEC saying you were illegally trading in securities. You're going to have to give the money back. Well, that's a problem, right? Now, they're a publicly traded company. They dealt with the SEC in getting publicly traded. The SEC could have stopped it, right? And they didn't. And so now they're coming back years later saying, oh, by the way, you're dealing in unregistered, unexempted securities. That's a real problem. Now, the fact is, and we come back to the core concept, the law is what courts say it is, because there is, so let me put it as gently as I can, the SEC doesn't get to just say all cryptocurrencies, all crypto assets are securities, and that means that they are, because the law is what the court says it is. And the courts have been dealing with a fairly famous Howey test for some time now, 1946, in fact, the SEC versus W.J. Howey and Company. The Howey test goes something like this. If I give money, right, if I invest money into a common enterprise with the expectation of profit, right, that I'm going to get money back from the efforts of others. Y'all are going to be doing the work. I'm not going to do it. I'm going to give you my money. You're going to work, and I'm going to get profits. That is a security. And what's great about the Howey test, again, 1946 is when it came out. There are reams of court opinions on this thing, right, since then, that have made securities out of, stocks and things like that, but also like Orange Grove stakes in W.J. Howey, right? The Howey test does not go away because the SEC says this is a security. What they are saying is, in assessment, we internally believe that by operation of the Howey test, you are selling an unregistered, unlicensed security. Fine, you can say that, but the fact remains that I have a number of clients who deal in some type of crypto asset. And their question to me is, are we going to have to give all the money back? And that's a really important question. Now, the answer is it depends, because I'm a lawyer and that's how we talk, right? We can do the analysis. The real key here is knowing how your software works, knowing what it does, and being able to explain it in a clear and succinct way that says it is or it isn't a security. Now, by all means, folks have been traipsing around this area for a better part of a decade, right? And the fact is that many of them are dealing in securities, and they just didn't care, right? People like to raise money. They like to sell coins, an initial public offering, et cetera. We want money for our coins. Well, the fact is, right, securities laws exist to protect you and I, the general public, right? Folks who don't know, the folks who are in that gap, right? Post-gap, right? So that's the framework that I'm taking a look at this from, right? I could talk about it for hours and hours and days. There are many more experienced securities lawyers who deal in it every moment of every day, right? But the fact remains the Howey test is the core decision, because if the SEC says you are selling unregistered securities, it needs to go to a court to say, in fact, that is the case. SEC versus W.J. Howey and Company, right? There is not a concrete answer. The answer is don't panic, proceed appropriately with caution, not blindly, right? Speaking of which, let's talk about DAOs. DAOs have been mentioned a little bit by now. I'm a business and corporate lawyer, right? By the way, this is not a promotional talk, like, believe me. This is me saying, look, DAOs, for all of what's been talked about before, are a corporate entity. They are not human beings, clearly. They're not trusts. They are organizations of people. Now, DAOs are only recognized, by the way, I'm glossing over what is a DAO because y'all did a great job of explaining it before, but they are collections of people engaged in some type of activity, generally speaking, a business till now, right? Profit-raising activity. So let's talk about Sarkoony versus BZX DAO. And at the risk of this turning into a law school class, I'm going to give you some facts behind this case out of the Southern District of California down in San Diego down there. A group of people decided to open up a DAO, and that DAO was going to operate as a financial exchange. And they collectively raised money from a number of people, and they intended for this DAO to operate in a way that would avoid regulatory authority. And I promise this is the only block quote that I will give, but I have to give it because I think it's really important to look at how these founders saw things. This is where idealism and realism clash. We're not in a brave new world of a different universe. We exist in the same world. The sun rises, the birds tweet, and we have laws. But here we have this from the authority, or rather from the founder, on a public call to their investors. He said, well, what we're going to do is take all the steps possible to make sure that when regulators ask us to comply, that we have nothing that we can really do because we've given it all to the community, right? Doesn't that sound great, right? High-minded, right? So the trouble is that they were employing this software developer. That developer fell for a phishing scam. The software got hacked and $55 million was stolen from this DAO, right? And people were righteously pissed off. And a group of folks who had collectively lost about $1.9 million became putative class action representatives and sued the DAO on behalf of the class. And what's interesting here, what the court found was because these guys had taken such a cavalier attitude toward a DAO, by the way, DAOs are recognized as corporate forms in Tennessee, Wyoming, and Vermont, I want to say. Don't hold me to that, but there are only a very small handful of authorities of states that recognize these as actual corporate forms, which is important, right, for what happens next. These guys didn't register the DAO because it is an ethereal entity that just belongs to the universe or something like that. I mean, I don't mean to be pejorative. It's just that this is kind of how it shakes out. The court said, no, actually, because you failed to register, what you're actually doing is you're engaging in a general partnership, which for any of the lawyers in the audience understand that a general partnership is absolutely the last corporate form you would possibly choose, because it means unlimited exposure on a personal basis for everyone involved. Well, who's involved? Well, we talked about governance tokens. Everyone that holds a governance token, the court found, is a general partner, which means that everyone who holds a corporate governance token is on the hook jointly and severally, which means I have to pay the whole amount. I might try to recover it from my fellow governance token holders, but the fact is I'm on the hook for $55 million in negligence-based losses. That's a problem, right? We don't live in a world apart from laws just because we are in Web3 land, right? We will reason by analogy to get us here. And so it's important to keep that in mind, right? There are precedents that we will use. And as lawyers, right, as a lawyer in this space, let's maybe be a little bit more exact, my job is to stand there and tell the court, because that's where the law is, what the analogy that I believe is correct is and why, right? So the last bit I want to talk about is the Uniform Commercial Code. Uniform Commercial Code is a piece of state law. It is not federal law. This gets a bit personal for me because I sat through all the meetings on this thing. The Uniform Law Commission is the group that drafts it. they draft this amendment to the Uniform Commercial Code, right? And they circulate it among the states, and states can choose to adopt it. But the Uniform Commercial Code is kind of like the roots of the tree that Dr. Charles talked about before. We don't see it, but we interact with it every day because it governs the sale of goods between states. Now, what is a good? A good is anything that is not a service, right? So if we're moving these chairs to Idaho and selling them, the Uniform Commercial Code governs, right? What else it does is it governs secured lending, which is collateral that is not mortgages. And why that's important is that $1.7 trillion that we talked about before. This is money that I can collateralize right now, but it's at super high interest rates and super shady lenders, and like DeFi is where all that stuff was stolen from those charts you saw earlier. So that's a big old problem. And what these amendments to the Uniform Commercial Code do is they include what is possibly the world's most boring term for cryptocurrency and crypto assets, controllable electronic records. Controllable electronic records are now what the UCC considers crypto assets as, and what that means is that there are concrete terms under which these things can be lent by major lenders and relied on by major lenders, right? And frankly, personally, this is phenomenal. Like the fact that people are going to be able to take their crypto assets and lend against them, right? Because how do you get your money for your Bitcoin right now? Like how do the crypto bros buy their Lambos? Like they have to sell it, right? Or lend it out at some really shady circumstance, like I mentioned, right? What this says is that major banking institutions can now accept that risk because they know what this is, what the schema is, right? And so this fantastic and talented group of people put together these amendments and launched them out to the states. 2 states adopted it, North Dakota and New Mexico. Colorado's got it pending, and I've been following it very closely. And one thing I want to put out there, just because I can, is that it hit the governor's desk after passing both houses of the legislature and was pulled back because of a kerfuffle out of South Dakota and Florida, which made the news about a month ago or so. This is just by way of public service and clarity. Here it is not political. The fact is that the concern was, A, that the UCC amendments removed from the definition of money, cryptocurrency specifically excluded it. People said, no, cryptocurrency is money. Well, the fact is that in that code, money is literal dollar-like paper and metal coins, and so doesn't apply. So whatever, that one's an easy one. The more difficult one to deal with was that it created a subclass called electronic money. People conflated that with central bank digital currencies. Central bank digital currencies, the frankly conspiracy theory goes, is that the government will get into your wallet and tell you what you can spend your money on and pull all your money out if they want to at the click of a button, which makes it even easier. Putting aside the fact that the government can seize your assets anyway, this is a bunch of nonsense that it's not part of the UCC. The UCC, as I mentioned, is state code, right? It is not federal law. It cannot create a monetary system. It cannot authorize a monetary system because, as we all know, it is federal currency that we're talking about. So there is this big fear that the CBDCs will come out of these UCCs, and that's what they're for. Unfortunately, it was too difficult politically to push back against this, and so electronic money was removed from the current version, which is kind of a shame, because if you have something like this pass, you'd like it to be whole and cohesive, and right now it does carve out this unknown for countries that have developed their own central bank digital currencies. Now we don't know what exactly to do with them. So that's an issue. Overall, though, it is great to have certainty. We can always work at amending these particular states' laws, but the fact is that there is work being done here. Now, the last bit I want to mention, because we're short on time and I do want to respect your time here, is a public service announcement, which is to say, most of the calls that I get are with scams. And if nothing else that you walk out of here from me with is that we've talked a lot about the confidence building in this technology, right? And the fact is that the core of the value that folks place in cryptocurrencies comes from confidence. But what else comes from confidence is cons, right? Con jobs. They're confidence jobs. So what does this look like? Well, the range of calls that I've fielded involve things like we have an inside track to making a ton of money off of Bitcoin. Give us your cryptocurrency or give us your money. We'll buy cryptocurrency with it. Oh, by the way, we just got found out. Run for the hills. This is a literal thing that I faced. Another one is we've got this great, investment deal here. You need to give us all your money. Oh, it's been frozen. You need to pay taxes on it. There's always taxes involved or some kind of fees to get your money back. Your money is gone by that point, by the way. It's gone. It was never on the blockchain. It never became cryptocurrency. It was gone the minute it was sent, right? And then the ever-present, non-pejorative lonely hearts folks. I met someone on insert social media platform name. They were really charming. I'm a lonely person. Well-heeled professionals fall victim to this most often. I've spent my life working. This person was exceptional in investment. They had they had made a lot of money and they wanted to help me do the same. And I gave them my money. And now the platform won't let me have it back without paying taxes, paying fees. A platform does not charge you taxes. They never will. You never have to pay more money to get your money back from a legitimate platform. By the time it's gotten there, it's far too late, right? If you have a loved one involved in this, right, do not give investment money to someone you have not met in person. Like, it sounds straightforward, but these folks are charming. Some people, that curve that you showed there, right? People believe we're in that green section still. We're not, right? There are not bajillions to be made overnight in cryptocurrency. There is not some hidden formula to cryptocurrency. In fact, the major 18%, I guess, market cap value Bitcoin, it's public. You can see where it is right now, right? If somebody's telling you it's made 300%, it hasn't. There's not some hidden Bitcoin, right? If there's a takeaway here for folks who are not lawyers, and that is that blockchain is not run by geniuses, right? It is not some last bastion of hope for the most technologically advanced and savvy of us. It can be explained simply. It was explained simply just here today, in fact. If someone can't explain it to you without using jargon, they're probably lying to you or don't understand it themselves. And do not give money to people that you meet on social media, right? Meet someone in person. It sounds very simple, but I'm tallying these things. And by the way, it's a very small section of folks that I can help with that. Most of it is just gone. We're talking about life savings type money. In fact, over 1 week, about 2 months ago, I tallied about $5 million in lost calls in a week. And it wasn't that many calls that I was taking, right? And that's $5 million gone, right? Hardworking folks just trying to make by. Some of them were trying to, get a little windfall. There's nothing particularly wrong with that. But it's easy to come down on folks like the SEC, right? But the fact is, those folks need that regulation, right? That's what those regulations are for, right? So consider this like, the law is what the court says it is. All that any lawyer can do is give you a prediction at this point. There are no safe harbors. There is no do this and you'll be safe. But know and be honest and clear-eyed about your goals here. If you're trying to issue tokens to raise money, it's probably the same as trying to issue stock to raise money. This is not a new idea. So if you're trying to get money, do it the legal way, right? we're not, we're blazing new trails in technology, but we're not blazing new trails in like overhauling the legal system, right? We've been doing this way for a while, and generally speaking, it works fairly well, right? It can be adapted to work better, but it's not like we're going to go live in Web3 world and never be found in the real world again, right? We still have to show up in court if we do it the wrong way. So best to do it the right way on the front end, right? That's my time. Thank you guys. I'll be around for any questions, but thank you so much for being here.